Is liberty dying where you live? Escape to Keene at freekeene.com.
Have some advice. All right, I have 3 or 4 files here. Notice a motion to impose. Which is the trial today?
The trial is on the contempt charge, docket number
From May 4th?
CR 1199 to May 4th, yes.
2013.
Correct. And there are 2 motions to impose. One is for docket number 12 CR. Actually, I think I may have filed a compliant motion. Docket number 2453, 2506, and 1428. One concerns a resisting arrest charge, where there was 60 days suspended, and then another concerns.
Is your last name E-O-N or E-A-N?
EAN.
All right. We've been ready to proceed. Do we need to go over the procedure with you here today? Or just,
I understand the procedure.
okay, any sequestration here?
I'm not asking unless the defense is asking.
No?
No, I don't believe we need
Okay.
sequestration. Will we be hearing the motion to impose prior to having trial?
No, the motion to impose is basically, a lot of that turns on what kind of evidence I hear here. They based it on, I would think, is that right? I
Yes,
didn't review the motion.
that is true, Your Honor.
All right, so we typically would do the trial first and then do the motions to impose.
I just want to clarify one point. I did file a motion to amend the contempt charge, and then I subsequently filed a motion to withdraw the motion. So I'm looking to essentially leave it as it was originally filed.
Okay.
And I didn't see a ruling on the subsequent motion to withdraw, so I just want to clarify that that's all set.
I'll grant that motion.
Thank you.
Okay, you ready to start?
I guess I just have a question as to whether or not the prosecutor is satisfied with the evidence that we'll be introducing at trial. I don't know if she's had a chance to preview it yet. If not, I'd be happy to share that information with her.
I think he's referring to a CD that he tried to submit pre-trial that I objected to, and the court indicated that it would be improper to submit evidence pre-trial. I did indicate in my response that I was not able to open the film and the video clips that he might be seeking to introduce today. I'm going to reserve my opportunity to object as he tries to submit this evidence, but I will offer that he just recently provided that disc in its original form that he submitted to the court, and the court did order on March 14th that pretrial discoveries to be complete within 30 days. So it's clearly beyond that 30-day limit. I will also add that I wasn't able to open it, like I just said. He gave me a disc this morning, which isn't helpful to me. I don't have a way of viewing it.
So you have an objection to?
I object, right. He's beyond the 30-day limit for March 14th. The court set for pretrial discovery. Also, I'm not able to see the content of what's in there, so I don't know what he's going to try to do. And I anticipate objecting the ring trial to some of this, or all of this evidence. It depends on what it is. But I'm reserving my opportunity now, depending on how the court rules on the lateness.
Trying to find this. When did you say the ruling of discovery was? March?
I can provide the court with that.
Well, I guess make sure I have the one that should be in here.
Yeah, it reads order regarding continuance and non-attorney representation. It's dated March 14th.
All right, I'm looking at the order from March 14th, Mr. E, and it says that pretrial discovery was to be completed within 30 days of March 14th. So, state's objecting, saying that they didn't get the discovery that you're trying to offer here today until 3 months after that, well, actually 2 months after the deadline.
It's on June 2nd.
I'm not aware of having received a correspondence from the state at that time.
It's not correspondence, it's a court order.
Okay, I don't believe I received a copy from the court either.
Well, you're representing Mr. Colson. They allowed you to do that, but it's your responsibility to acquaint yourself with the file as any other representative would. And there's no compliance here.
Okay, well, my apologies for
You may have to apologize to Mr. Colson. It's not, you don't have to apologize to the court. It's just that was an order that wasn't complied with, and I'm not going to allow any other discovery. So,
well, in regards
I'll allow you to put on your case, but I suppose there might be some objections to certain information. I don't know how the case is going to go. I don't know anything more about it than what's in the complaint. So, all right, we may have to deal with these things piecemeal as we go along, but as far as any failure to comply with the pretrial order, that's your responsibility.
Okay, and also on that note, I was just wondering if I would be able to use a map of Keene, just print it off of the internet. The prosecutor would like to review it.
If it's something that would assist the court and the parties in understanding what you're pointing out, I mean, I don't. Was this alleged to have occurred?
Downtown, around Main Street.
All right. Well, of course, fairly familiar with the downtown area. If any points of contention come up, and the map might help clarify that, we can deal with that at the time. Okay. Anything else?
No, the state's ready to proceed.
Okay.
State calls Alan Gibbett. You can please remain standing and raise your right hand. Do you swear or affirm that the testimony that you're about to give in this matter is the truth and that the pain and penalty of perjury?
I do.
Okay, if you could please have a seat. If you could state your full name and spell your last for the record.
Alan E. Gibbets, G-I-V-E-T-Z.
Can you spell that one?
A-L-N.
Spell your last name again, please.
G-I-V-E-T-Z.
Okay. Thank you.
Are you a resident of Cheshire County?
Yes.
And how are you employed currently?
I work in a machine shop.
And doing what?
Just cutting materials, preparing.
Okay, drawing your attention back to April 17th of last year, 2013, how are you employed then?
I was working for the City of Keene Department of Enforcement.
Okay, and what was your specific position and what were your duties?
I was a meter maid, just in charge of collecting meter funds, issuing meter violations, 2-hour parking violations, basically parking tickets.
And how long were you employed as a parking enforcement officer?
I believe it was just under 2 years. I'm not exactly positive.
Okay. And what do you recall about the date that you stopped working for the City of Keene as a parking enforcement officer?
I believe it was in the summer.
Of 2013?
Yes.
And did you wear a specific uniform for the job?
Yes.
And what did that uniform look like?
Depending on the seasons, it was in the winter we had a jacket that said Keene Police Department on it. We had like navy blue khakis, I would guess you would say, and a navy blue polo shirt. The only thing we carried other than that was radio and then our little ticket writer.
Okay, like a handheld device?
Yes.
And on the date, April 17th of last year, 2013, at about 2:30 in the afternoon, approximately that time, do you recall where you were and what, if anything, occurred?
I'm confused on the dates because it's been so long. Are we talking about which incident are we talking about?
Do you recall an incident happening at the Center Square?
Yes.
And what happened?
I walked through Central Square. I took a right, just right in front of the white church at the top of the square. And I walked through, and Mr. Colson followed me through. And that's when I started to make a phone call. And Mr. Colson stated something, "What are you calling the cops? Cop caller, coward." And then he immediately left the square, stood outside the square, and continued to call me cop color.
Okay. And why, and what were you doing? Were you in fact calling the police?
I was, yes.
And why were you calling the police?
Because I was aware of the no trespass order in the square.
Concerning Mr. Colson?
Yes.
And do you know his full name?
I believe it's Graham Colson.
Do you recognize Graham Colson in the courtroom here today?
Yes.
And where is he seated for the record? If you could describe what he's wearing, perhaps?
Black glasses, black shirt.
Will the record reflect the witness identified the defendant?
Will.
Thank you. And who, is it your understanding that the Keene Police Department did pursue an arrest warrant for Mr. Colson for criminal trespass?
Yes, it is.
Based on that particular incident you just described?
Yes.
And is it your understanding that he was arrested
Yes.
and there were bail conditions?
Yes.
And was one of those conditions, did a condition concern you particularly?
One of the conditions was no contact order with me.
Okay. And drawing your attention to May 4th of last year, 2013, at about 10:40 in the morning, were you also on duty as a parking enforcement officer?
I was on Main Street at the time.
Okay. And whereabouts in particular, specifically, were you?
I was heading towards the square on Main Street. I was right in front of Local Burger.
And what were you doing at that point?
I was reading the meters.
And what, if anything, happened that you recall?
I started heading towards the square and I noticed Mr. Colson coming, and I was aware of the no contact order, so I tried to do the best I could and just avoid eye contact with him. And I looked left towards the meters and parked cars. And as we walked by, I heard Mr. Colson say cop collar, and then he kept walking.
Okay. And do you remember about how close in proximity he was to you at the time he passed you?
Like I said, I looked left, so it's hard to tell. I believe he was in arm reach, but I can't be certain.
Thank you.
All right, Mr. Egan, you have any questions?
At the time described that the no trespass order was allegedly violated by the defendant, that was in April of last year, how well have you been acquainted with the defendant?
I've known Mr. Colson up to that point, I guess you could say, personally and professionally, from him following me doing the activity called robbing hooding for roughly a year or so.
How would you describe your relationship with Mr. Colson?
Honestly, rocky at best. Some days were better than others. Some days were, it'd get very personal with me.
Something rocky, you said?
Yes, sir.
What exactly would Mr. Colson do that would bother you?
Projection elements.
And why is this relevant to a determination I have to make here today?
The mindset of the defendant in this case and his relationship to, the mindset of the witness in this case and his relationship to the defendant is an element of the matter which may have motivated the actions of parties involved. So it comes with the heart of the matter.
If it tends to show bias or prejudice on the part of the witness, I'll let you ask the question, but at least I might have to impose some limits on how far you go with that. Okay, so you can ask the question again.
So you said that the defendant would make it personal. I believe you said, could you describe that, what that meant?
He would make comments based on my religious or my military status. He made a comment calling me a racist, said I condone the droning of brown babies. He would make comments about my wife. I don't know how much you would like to know.
Over the course of your relationship with Mr. Colson, did you ever understand him to be a physical threat?
He would get very close and
Objection relevant, Your Honor. See how this is relevant.
Why is this relevant, whether he's a physical threat or not?
The imposition of no contact orders with witnesses is usually based on the position of the court that there may be some sort of threat to the individual parties involved. So since there is no contact order involved in this case, understanding whether or not one thought that somebody was a physical threat or any other sort of issue is relevant to the case.
Well, bail conditions are imposed for a variety of reasons. Physical threat is one, but it's not relevant to this case. As long as you sustain the objection.
Had you previously sought conditions of proximity restriction upon Mr. Colson?
Objection to. What's the relevance of
Again,
Whether or not the defendant had a pattern of seeking a means to limit the defendant's ability to be within a certain proximity of him?
well, the only limitation that I'm trying here today is the one that's alleged to have been imposed by the court in a prior court order. And it would be up to the court to make those limitations, irrespective of who was asked for them. So again, I'll sustain the objection. Relevance means is what you're trying to introduce, is it makes a factor or some issue that's in doubt one way or another more or less likely than it would be if I didn't get the evidence. That's not going to help me make that determination one way or the other. That's when we talk about relevance.
Understood. Do you remember when you became aware that Mr. Gibbets had a no trespass order pending or currently over
Mr.
him
Colson?
related? Mr. Colson. Mr. Colson related to Central Square?
The exact time, I don't, during my employment with the parking department at some point.
Do you recall if someone informed you of that condition on Mr. Colson?
Objection, I don't see this is relevant either.
Okay, you can ask a question. I'm not sure where you're going with it, but I'll let you give it a try.
I don't recall personally if somebody told me or if I read it via an email when working for the department.
On the day that you were walking through Central Square and Mr. Colson also walked through Central Square, were you expecting that he may walk with you through Central Square?
You're talking about the April incident that was referred to?
Yes, April.
I wasn't expecting it, honestly. I thought I was aware of the no trespass order, and I was hoping that he wouldn't follow me through and I would have a chance to get away for a few minutes.
On the day of that arrest of, actually, let me rephrase it. After Mr. Colson was arrested on the no trespass order in Central Square, were you informed by any of the staff at KPD about that arrest?
I had heard it somehow. I don't remember how I heard it. I don't know if it was personally or if it was, again, via email.
How were you made aware that there were no contact orders issued as a condition over Mr. Colson regarding yourself?
When I had heard that he was arrested, I asked, because working in law enforcement, I kind of thought that if I was involved in the case that there would be no contact order, so I wanted to make sure my information was correct.
So you inquired with the Keene Police as to whether or not there would be a no contact order?
Yes.
Having known Mr. Colson, you said for about a year, do you know anything about his eyesight that may limit his abilities?
Objection. I don't think this witness is qualified to testify.
He was only asked if he knows anything, that's all. You can answer that question.
I had heard, or rather I should say I saw something on YouTube with Mr. Coulson saying that he was half blind.
Objection that calls for speculation and hearsay, Your Honor.
What's your response to that?
Well, I would say that it does not call for hearsay because the witness has identified as having had some relationship with the defendant, so I'm asking about his personal experience with the defendant, not his experience of others regarding the defendant.
I would say anything he heard on YouTube is certainly hearsay. Any statement that he heard, I don't think it would fall under any exception to the hearsay rule.
He can say what he saw on YouTube, but it's not for the truth of any matter. So in other words, if he saw something, that's one thing, but that doesn't prove that Mr. Coulson has any problem with his eyesight. That would have to come from some competent witness or another.
Over the course of your interactions with Mr. Coulson, have you ever observed him looking at meters?
Yes.
Did he ever appear to squint?
I don't know.
Appear to what?
Squint.
I'm not sure. I tend to not examine what he's doing very closely. I tend to worry about my job.
Over the course of your relationship with Mr. Coulson in regards to the Robin Hooding activity, have you made many public statements about Mr. Coulson?
To who?
Any statements that would be,
I would object to this. I think that now he's starting to get into some of the discovery that he just barely submitted a couple of weeks ago.
It's hard for me to make a judgment without knowing what that discovery purports to be.
I think Mr. Ian can confirm that.
well, I'm asking about whether or not the witness made public statements related to this matter.
This particular matter that I'm trying here today, or to other related matters?
Well, I believe asking the questions would see if they're related to this particular matter.
That's not what your question was. The question was, did he make statements about Mr. Coulson?
Yes.
And I guess my question is, do you make statements about Mr. Coulson relative to this particular case or to other issues?
Well, that's what I'd like to ask, if it is related to this case.
Well, if you can ask him if he made any statements about Mr. Coulson with respect to this particular case, I'll let you ask him that question, and I'll ask him to answer that.
Okay, so have you made any public statements relative to Mr. Coulson?
The only statements I would make...
No, the question on this particular contempt charge that's being tried for today, that's the question that you can ask.
Okay, what have you
The one you just asked was rather open-ended. That's not what, I'm not going to permit that.
Okay, have you made any statements relative to the no contact order between yourself and Graham Coulson and facts relating to that situation?
Again, to this particular case, the contempt case from May 4th, you can ask if you made any statements about Mr. Coulson relative to that particular incident. And you're kind of dancing around the question here. That's got to be a very specific question, otherwise I don't think it's relevant to this case.
Was the last question objected to?
Well, it was objected to. I'm giving you an opportunity to ask the question, but only as to this case. It's not a general question I'm going to allow you to ask.
Okay. So, Mr. Gibbons, did you make any public statements relative to this case?
I'm so confused right now.
This case is based on a complaint that alleges that Mr. Coulson violated bail conditions on May 4th, the incident that you testified to on direct. And Mr. Ian is trying to ask you whether you made any public statements about Mr. Coulson with respect to, if you made 1 million statements about Mr. Coulson, that's one thing, but did you make any statements about Mr. Coulson with respect to this incident? That's the question I'll have you answer, if you can answer.
Okay. The only statements I would make regarding this case was the fact that all I said was, to my knowledge, there was a no trespass order, and also that there was, I guess, a violation of the bail conditions when he had contact with me.
Did you make any statements regarding Mr. Coulson in the time after he was arrested for violating the contact order?
Again, if the question, it sounds like you've asked the question the second time, the the only one I'll let you ask is, did he make any statements, public statements about this case? You see, obviously he didn't make any before this happened. If he made anything coincidental with it happening or subsequent about this case, that's fine. I realize that there may be other issues where the witness has made public statements. I haven't seen any, but that's the only one I'm interested in hearing from.
So, from what my understanding is that I'm prohibited from asking questions that may demonstrate that the witness may have a bias or an animus against Mr. Coulson, even if those statements were made following the...
I'm only talking about this particular case here. He made statements with respect to how he felt about this particular case.
Okay, well, I believe that's excluding some of the evidence, but... Mr. Gibbons, did you make any statements regarding, scratch that. There have been previous court hearings related to your relationship with Mr. Coulson, correct?
Objection, Madam Chair.
Well, I'll let him answer that question and see where it goes.
Yes.
And you made statements regarding your relationship with Mr. Coulson over the course of some of those hearings in the Cheshire Superior Court, correct?
I did make courts in Superior Court, yes.
And you did admit to threatening the safety of Graham Coulson at one point in time in court, correct?
Objection, Your Honor, again, I don't see how this is relevant to what the court has to
Sustained.
decide.
Has there ever been an incident in which you threatened the safety of Graham Coulson?
Objection.
What's the relevance?
It's to demonstrate that Mr. Coulson, despite having orders applied to him that he was forced to follow, that he never demonstrated any malintent towards, any criminal malintent towards Mr. Gibbets. However, there's a question as to whether or not there had been some negative intention on the part of Mr. Gibbets towards Mr. Coulson in that.
Well, that's not relevant. The second part is irrelevant. It may become relevant if in fact the court found Mr. Coulson guilty. You might be able to argue in mitigation as far as sentencing is concerned, but as far as this case is concerned, it's not relevant.
Mr. Gibbets, have you ever posted statements online supportive of criminal threats being directed against Mr. Coulson?
Objection.
I'm going to order you at this point, Mr. Ian. I've allowed you to represent Mr. Coulson. At this point, no more questions about other statements unless they go directly to this case. This is 3 or 4 times that we've been at this point. No more.
Understood. Mr. Gibbets, do you understand the bail conditions on Mr. Coulson, with respect to the no contact order to be current?
I don't know if they are or not.
So you're unaware of whether or not those bail conditions expired at some point?
I am unaware, yes.
Have you ever felt threatened by Mr. Coulson?
Yeah.
I will throw. Nothing further.
Okay, thank you. And you redirect.
No, Your Honor.
Thank you. Step down. Thank you.
State Health Officer Bruce Gomez. Please raise your right hand. Do you swear or affirm that the testimony that you're about to give in this matter will be the truth and the pain and penalty of perjury?
I do.
Okay, would you please have a seat? You can state your full name and spell your last name record.
Bruce Uhas, U-H-A-S.
And how are you employed, sir?
I'm employed by the City of Keene as a full-time police officer, and I've been so employed since April of 1994.
Are you a certified law enforcement officer of New Hampshire?
Yes, I am.
Drawing your attention to April 17th of last year, 2013, at about 2:37 in the evening, were you on duty for the Keene Police Department?
Yes, I was.
And do you recall becoming involved in an investigation concerning Alan Gibbons?
Yes.
And what did you do in furtherance of that investigation?
There were two of the parking enforcement officers that provided a statement as to Mr. Colson following Alan into Central Square. There was a trespass letter prohibiting him from being in Central Square. So from that, I made an arrest warrant.
Okay. And did you, so you obtained a valid arrest warrant to arrest Graham Colson for civil trespass?
Correct, yes.
And the following day, did you effect that arrest warrant on Graham Colson?
Yes, I did.
And was that at about 11:30 in the morning?
Yes.
And do you recognize Graham Colson in the court here today?
Yes, he's seated here to the right.
Will the record reflect the witness?
Yes.
And after you arrested, or can you just describe where you arrested him?
He was in the alley near the 109th shelter.
Okay. And did you take him to the Keene Circuit Court for an arraignment?
We went to the PD first, and from there we went to the 8th Circuit District Court. It was at the old location.
Okay. The City Hall building.
Correct.
And did you appear before Judge Burke?
Yes, we did.
And did Judge Burke set bail conditions concerning Mr. Colson?
Yes, he did.
And would seek to enter State's Exhibit 1, a certified copy of the seal of the bail order?
No objection.
State's Exhibit 1.
Counselor Hudson, what you do is an end of State's Exhibit 1 is that a certified copy of the bail conditions that Judge Burke set on that day.
Yes, it is.
And does one of those bail conditions concern Alan Gibbons?
Yes, shall have no contact with parking enforcement officers Lynn and Allen.
And what does the rest of that line read?
By mail, telephone, or otherwise, and it is further ordered not to interfere with a person at their residence, school, or place of employment. And additionally, it is ordered to refrain from going within 100 yards of where that person may be.
And were you present for the arraignment throughout the entire hearing where Judge Burke reviewed those particular bail conditions with the defendant?
Yes, I was. An important part here, I was going to pull up my report for the spelling of the last names, but that was not needed because it was obvious who this Lynn and Allen were.
And is there any other parking enforcement officer by the name of Lynn or Allen?
No.
There's only one of each.
Correct.
And did Mr. Colson indicate that he understood the bail conditions that were being set by Judge Burke?
Yes, he did.
And how did he do that?
He acknowledged, I don't remember exactly, he acknowledged that he understood.
Did he also sign that bail order?
Yes, he did.
And was that in your presence?
Yes.
Thank you.
Okay, Mr. Ian.
Approximately how long have you been a police officer?
20 years.
And over the course of those 20 years, you've probably written plenty of reports?
Yes.
I imagine in completing those reports, you're dealing with lots of information and sometimes contradicting information, correct?
Correct.
So as a police officer, I imagine it's important to use objective language in composing their report so as not to, you know, sway for one witness or one way or another.
Okay.
Do you recall writing a report relative to the trespass, the arrest of Mr. Coulson related to a trespass order in Central Square?
I wrote many reports that involve Mr. Coulson.
Permission to show this report to witness?
I'm not sure what the question is that he's going to ask.
Yeah, is there a date or something we can refer to?
Sure, this is the narrative plea for Police Officer Bruce J. Uhas, relative to criminal trespass, reference number 13921.
Is that a date on it or a reference to a particular incident in there?
I do know what report he's talking about. I'm just not sure that the question is going to be.
Okay, in your report, you noted that Coulson is well known as he has been following the parking enforcement officers, harassing them. Do you recall writing that?
Objection relevant, Your Honor.
Calling issue to the, drawing attention to the officer's report in this case?
Well, he hasn't testified that what you're holding in your hand is the report that from this incident, so you need to get over that hurdle first. Not a very high one.
Okay, may I show this report to you?
Sure.
Do you recognize that to be your report?
Yes, it is.
Okay. Give it back.
Officer Uhas, drawing your attention to the first paragraph, second sentence. Coulson is well known as he has been following the parking enforcement officers, harassing them. Did you write that?
Yes, it did.
Okay. Are you aware that in writing that Mr. Coulson is known to have been harassing parking enforcement officers, did you make any efforts to secure a warrant for the crime of harassment under the state of New Hampshire?
What's the relevance of whether he took any action based on that? How does that help you decide this case?
By speaking in criminal terms about the defendant, Mr. Coulson, it's creating a bias against him systematically that Mr. Uhas is in his report accusing him of being guilty of a crime in New Hampshire without having even made any effort to
whether he is or isn't, how does that bear on whether or not Mr. Coulson violated the bail orders on May 4th?
Well, it's relative to the circumstances that led to Mr. Coulson having bail conditions of that sort.
Well, to the extent that the recommendation for the no contact order came from Officer Uhas at that hearing, I'll let you ask that one question, and that's it.
So, Officer Uhas, you were the person who inquired about having bail conditions placed upon Mr. Coulson's relative to no contact.
Correct in that it's common practice for that.
It's common practice for there be a no contact order for witnesses of a no trespass in public?
That as well as many other cases.
So there's no other metric for applying a no contact order beyond someone just having witnessed a sort of civil infraction?
What's the relevance of that? The question is not what other choices were available. The question is what was ordered and whether or not your client violated what was ordered. The fact that other choices were there is not relevant.
Okay. Officer Uhas, in your report, you note that you are unclear as to whether or not Mr. Coulson had a valid no trespass order in the square at that time, correct?
recall something to that nature.
And after having checked the database, you discovered that he did in fact have a valid no trespass order.
Correct?
And you inquired with Mr. Gibbons and Ms.
Sorry.
Russo.
Ask that again. I was coughing, could you ask that question?
So after you found out that Mr. Colson did have a no trespass order for the square, you informed the two parking enforcers about that no trespass order?
I don't recall specifically how the conversation got there. There ended up being a conversation about there being the letter still valid and them still following parking enforcement officers into the square.
In saying them still following parking enforcers into the square, is it to be understood that the defendant would be following the parking enforcers into Central Square, perhaps?
No, my word was incorrect because it specifically is for Mr. Colson.
You were aware that the no trespass order expired on May 10th of that year, correct?
I don't have a specific recollection of that.
When you're talking about the no trespass order, you're talking about a letter of no trespass or a court order?
There was a letter of no trespass that applied to the defendant.
So when you say order, it wasn't a court order, when you say order, okay.
So you said it is common practice in witnesses to an infraction to seek a no contact order. Do you ever seek input from the parties to that no contact order as to whether or not they believe that should be sought?
You confused me.
In inquiring with the court about a no contact order relative to a defendant and witnesses, do you inquire first with the witnesses as to whether or not they would like that to be sought?
Not necessarily.
If you are granted a no contact order between witnesses and a defendant, do you inform the witnesses of the conditions of that order?
I made it clear to Alan and to Lynn after the bail was completed that there was no contact, that Graham was to have no contact with them.
Did you inform them that the prohibition on contact included a distance of I'm sorry, I don't have the order in front of me. Do you recall the distance of the order by which Mr. Colson was not to be within Mr. Gibbons or Ms. Russo?
Again, when you're talking about order, you're talking about the bail condition or the letter, the no trespass letter?
The bail condition.
I don't recall specifically what it was. I'm guessing, I think it was 300 feet, but I don't recall specifically.
And of course you knew the two parties to the no contact order to be public employees who work in the downtown?
Correct.
I have a map of the downtown. Looks like the distance between across Main Street, including across the median, is about 50 feet. So that would mean that if someone has a no contact order with a restriction of 300 feet, that they could not even be so close as to the sidewalk across the street from someone with whom they had an order, correct?
I object to any statements about proximity, and I'm not quite sure I understand the question.
Could you rephrase?
Oh, I understand your question. Your question is that the order, someone may take a look at that order and say it's more restricted than it would need to be. Right? But that's not the issue. The issue isn't whether Mr. Colson was across the street. The issue is whether he was basically within arm, according to the testimony, within arm's reach of the First Amendment. So irrespective of whether that was reasonable or not, what you're talking about as being unreasonable has nothing to do with the facts of this case, at least as they've been testified to here today.
Is that a sustained objection?
Yes. So in other words, someone can come in, and if they think it happens every day, people think the restrictions are too great, and they come in and they ask for relief. Sometimes they get it, sometimes they don't. It depends on the circumstance.
Officer Uhas, at any point did you question the constitutional validity of the no trespass letter applying to the defendant relative to Central Square?
Objection, relevant, Your Honor.
Not relevant here.
Withdrawn. Noticed in your report seeking the no contact orders relative to Mr. Colson and the two parking enforcers, you wrote on it for who the contact orders apply to, PEOs Lynn and Allen. Are reports generally written that informally?
I think what you're referring to is not anything that I wrote.
Okay.
You're referring to what the judge wrote.
How well do you know PEOs Lynn and Allen?
I've worked there longer than they have, so I've had interaction with them for as long as they've been working there.
Would you consider them friends?
Sure.
Objection, relevant, Your Honor.
It could go to bias.
Did you believe Mr. Colson to have been harassing PEOs Lynn and Allen?
I feel as though their action was.
But you took no action to pursue criminal charges of harassment against Mr. Colson?
Objection, relevant, Your Honor.
It's not relevant which way. He may have had the opportunity to do that, and then what he did or didn't do in that respect is not relevant to, again, to this particular case.
Officer Uhas, if on a report related to, let's take a theoretical, if there was an instance of someone striking another person, the court may find it to be assault, but in the writing of your report, you would not report that, or would you report in taking information from one of the parties involved that one person assaulted another, or would you describe in non-legal terms the situation?
Why is it relevant?
Well, I believe that in using the term harassment to describe the activities of Mr. Colson, it's demonstrating a bias that Officer Uhas has against him. He's basically alleging that he's committing a crime that there has been no effort to pursue the defendant on.
I would offer a neutral and detached magistrate authorize the arrest warrant for Mr. Colson in the first place. Your Honor issued the bail order in this case. I don't see how this is any relevant cross-examination.
Anything else? All right, the objection sustained. Essentially, the ultimate determination is up to the court as to whether or not the evidence supports any such claim, and it's discretionary on the part of an officer as to whether or not any charges are going to be brought.
I have no further questions for the witness.
Thank you. Any redirect? Okay, thank you. And this witness be excused?
Yes, and the state rests.
All right, the state's submitted its case. Do you have any witnesses to testify?
Defense arrest, Your Honor.
Okay, thank you. The state's burden is beyond a reasonable doubt. The state's demonstrated that there was a bail condition in place and that the defendant violated the bail condition in the manner that was testified to by the first witness. And under the circumstances, the court finds the case has been proved beyond a reasonable doubt, finds the defendant guilty. Do you want to go to sentencing here, or do you want to do the motions to impose next, or how do you want to proceed?
Either is fine.
Do you have any preference?
The defense has already filed an objection to the state's motion to impose.
We have to hear the motions. I didn't know whether you wanted me to go to sentencing on this particular charge first, or you wanted me to hear the motions to impose after we get
I would ask to hear the motions first, Your Honor. Shall I begin?
Just give me a second here, because I've got a number of files. I wanted to get the right one in front of me. I guess what I'll let you all know is that what I would do is I would hear on the motions to impose, and then I'm going to go back and then I'm going to issue a sentence across the board depending on what the court finds. I've got a motion to impose. There's a 60-day sentence in the House of Corrections suspended on this is to 12 CR 2453250. Do you have the motions in front of you?
I have the defense's objection to the state's motion. I don't believe I have this.
I have your objection too. But is it one motion to impose on three different docket numbers? Is that?
Yes.
Okay, so I'm only looking for one motion to
Yes.
impose, and I've got that. Okay.
Yes, and the 60 days are concurrent from what I
Okay.
understand. And the fines, there are 2 fines and those are consecutive.
Okay, all right. On the motion to impose?
Yes, Your Honor. The state would ask that the court impose the 2 fines of $125 each. I'd also ask that the court impose 30 of the 60 days. As this court is aware, the state's burden in proving a motion to impose is less than the state's burden at a trial and by preponderance of the evidence. The court has to essentially enter a finding of misplaced trust. I think it's clear he feels as though orders and rules and laws don't apply to him. He was aware that he had 60 days hanging over his head on the condition of his good behavior. It was made clear when he was sentenced what would have, to the extent of what it would take to move to impose any of that time or the fines, including bad behavior. I think it's clear that he has been a bad behavior. He's committed the offense of criminal contempt, unlawful contempt in violation of this court's order. He showed a blatant disregard for this court's order. The order was issued on April 18th, and within just a couple of weeks, on May 4th, he violated it. He has convictions in this court for unlawful possession of alcohol on August 28th of 2012 and March 23rd of 2012. He has a conviction for disorderly conduct in August of 2011. He received a sentence of $250 fine plus a penalty assessment to pay. He was authorized by this court to complete 31 hours of community service. He never did that. He ended up serving 7 days in jail and with the fine. He was convicted in this court of possessing drug paraphernalia on August 28th of 2012. He received a sentence of $125 fine.
I don't see how that's relevant to this case.
So you have a lawyer or an attorney, a person representing you here, okay? They'll speak for you.
And finally, on September 14th of 2012, he was convicted again of city ordinance violation, possession of drug paraphernalia. He was assessed with a standard fine of $125 to pay. And on this date, those 2 convictions, he has over and over and over again been warned by multiple key police officers, Sergeant Schwartz, one of them, he's sitting right behind me, about certain city ordinance violations, including skateboarding. He continues to disregard the city ordinance, and he denies, he's given opportunities to avoid city ordinance violations, but he continues to skateboard. in violation of the city ordinances. This is not a case about anyone's animosity as much as defense wants this to be a case about how much Alan Kivitz dislikes Graham Colson and Robin Hooding. This is about Mr. Colson's violation of orders, rules, laws, and the state would ask that the court impose at least 30 days of that sentence and the fines that were suspended because he didn't know what would happen if he was not a good behavior, and he's clearly violated that. And does the court want me to address the argument?
I'd like you to address the sentence on the,
Okay.
in the case we just tried.
Yes?
Yeah.
Okay. And on the contempt charge, the state would ask that the court impose a sentence of 6 months in the House of Corrections suspended for 2 years upon his good behavior, and a fine of $500 plus a penalty assessment to pay. I'd also ask that the court order that Mr. Colson refrain from having any contact with Mr. Kivitz as a condition of that sentence. And what I would add in this sentencing argument is consistent with the goals and considerations in sentencing, punishment, deterrence, and rehabilitation. I think his conduct on the date that he violated the bail order was that of intimidation. I think it's clear he was trying to intimidate him. It's borderline witness tampering. He was calling him cop collar. It was a consequence for Mr. Kivitz making 2 reports to the police. I think he should be punished. I think that his time hangovers had to be a deterrent for future violations of state laws. And again, it was a blatant disregard of this court's order, and that's what this case is about.
Okay, why don't you address the recommendation on the motion to impose first, and then on the sentence on the contempt case.
The defense objects to the motion to impose suspended sentences for a number of reasons. One of the primary reasons being that the source of this original conviction that the state is seeking to impose was the no contact order, the no trespass order in Central Square. The no trespass order in Central Square was since dismissed by this court as an unconstitutional violation of the defendant's due process rights when it was issued to him. At the same time that while the defendant was ignorant of the fact that this was a violation of his rights at the time, he did plead guilty to avoid the consequences of a potential jail sentence hanging over him. He did this under duress and from a state of ignorance. At the same time, he was also being charged with resisting arrest. Now, if you look to the reports of the officers in those cases, resisting arrest consisted of Mr. Colson saying no and beginning to walk away from the officers when they approached him. Mr. Colson has not demonstrated any sorts of violent or threatening behavior, despite the insinuation that there may be witness tampering or intimidation by Mr. Colson that the state has made. The trespassing, of course, in Central Square is the fact that Mr. Colson had to deal with that case was a violation of his time, energy, and rights as a whole. And to hold over him a jail sentence or to impose a jail sentence relative to that case would be a further violation of Mr. Colson's rights. Central Square, there should be no reason why anyone had been banned from Central Square for not having even been convicted of a crime. The city acted unlawfully. They began preemptively issuing no trespass orders that the courts have since dismissed as unconstitutional. And in recognizing that, it would be improper to impose a sentence relative to that on Mr. Colson.
Did Mr. Colson ever ask to have the sentence reviewed or vacated for any reason?
Mr. Colson is under the impression that as if he remains of good behavior, that the sentence would not be imposed upon him. He doesn't have access to legal resources to be challenging all of these restrictions placed upon him to his fullest extent.
He's had legal representation in the past, hasn't he?
Only from public defenders and people volunteering like myself to help out.
But the order of March 14th also said if he was going to apply for appointed counsel, he needed to do that. But he didn't apply for counsel in this case either, correct?
He originally spoke to counsel, but he believed that they could not provide him adequate defense.
Okay, go ahead.
So I would say that concludes my objection to the motion to impose. And as far as the sentencing for the matter here before the court today, the case before us, if we look at Mr. Colson's history, we see a number of roadblocks placed by the institutions before him that have considerably labeled him as a criminal within the system, despite the fact that he's a nonviolent person. His history was brought up, alcohol possession when he was underage. At that time, it was the crime of being young. Possession of paraphernalia, a victimless activity, skateboarding. I mean, there's the discussion of jail time is coming into play here, and then the prosecutor is discussing the fact that he sometimes skateboards downtown. The matter of the no contact orders themselves go to the heart of whether or not Mr. Colson was even able to enjoy the downtown. While the no contact orders hung over his head, he was pretty much prohibited from being downtown, as Mr. Uhas testified, within the space of about 50 feet is across the street. So you have to be more than out of eyesight in order to be within compliance of these no contact orders. Essentially, Mr. Colson was prohibited from being downtown between the hours of 9 and 5.
But again, as it came out during the trial, he never, or was implied during the trial, he never asked to have relief from that order. He never came to court and said, you know, Judge, I've got, you know, I can't go downtown. I'll agree to stay on the other side of the street, but I think that's too restrictive on my movements. He never asked for that, did he?
I don't believe he had. We also have heard today about how this case involves all of the witnesses brought into court today. They're closely associated with one another. They work for the Keene Police. They have personal relationships with one another. And it also creates an environment that encourages extra legal privileges to be offered. And in this case, the defense feels that an extra legal privilege was offered in the conditions of this no contact order. Mr. Gibbets had sought legal remedies to remove Mr. Colson from the certain proximity of himself on more than one occasion previously to this incident. And it is demonstrated in that Officer Uhas, who is friends with that individual, was able to secure no contact orders, despite in this case that Mr. Colson never presented any sort of threat to the witnesses in this case. Essentially what he was given bail conditions concerning was whether or not he was in public, whether or not he was standing in public in the central square. The court has since ruled that's not a crime. I believe it would be an infraction upon Mr. Colson's rights to continue to punish him for the nonviolent action he took of occupying space in Central Square, which is everyone's right here in Keene. And it's unfortunate that it's come to this point. Now, in addition to the state seeking sentence, they're also seeking further no contact orders between Mr. Colson and the witnesses in this case. It doesn't seem necessary in the sense that those two individuals have been in public recently. There has not been any issue. Even though they have had what Mr. Gibbets describes as a rocky relationship, Mr. Colson has never been a physical threat to the defendant, to the witness, and the witness, though he has made statements that could be perceived as threatening of Mr. Colson, and in fact did encourage the threats of others in public statements that Mr. Gibbets made on Facebook. Mr. Colson has not responded with animosity or with anger himself. Mr. Colson should not be punished for not having the legal know-how or the resources to have challenged this sort of unnecessary order earlier. And I would hope that the court recognizes in this case that putting Mr. Colson in jail over this sort of what you could best call a disagreement would be an improper use of resources. The purpose of the jail primarily should be to incapacitate dangerous people from society. It isn't as though when you send people to jail that they learn something they didn't learn before. They're just made to be dependent. And it's very unfortunate. And Mr. Colson is not somebody that needs to be made dependent upon the state. The state has had him in their custody enough as he was growing up and through all of the infractions that are relatively minor, as Ms. Killen brought out, that definitely don't warrant jail time. And I don't believe that, and the defense does not believe that jail is an appropriate remedy for this case.
Thank you. Anything else?
I'll just add that I think defense's argument just lends further support for the state's position that he just painted Mr. Colson as a victim. He hasn't shown any sense of responsibility for his actions, namely violating orders of the court. I think he just, like I said, painted himself as a victim. I think that lends further support that he thinks that rules and orders and laws just simply don't apply to him. I think a message should be sent here.
All right, I've been reviewing earlier files. To some extent, I agree with the defendant. Some of the prior charges against Mr. Colson are relatively insignificant for sentencing purposes, and I'm not going to consider them. However, on the motions to impose on the suspended sentences, all I have to determine here is whether the defendant violated the trust, that is, if he failed to be of good behavior based on future conduct. And the evidence today was convincing in that respect. That's what the motion suspended sentences are all about. I mean, if you say, you don't have to go to jail, you're not going to, for all the reasons, or some of the reasons that your friend, Mr. Ian, just went over, that's true, but at some point, the integrity of the suspended sentence is rendered meaningless unless there's some consequences for future misconduct. So the sentence on the motion to impose is 30 days to serve. I'll have to get back to this in a second. On the criminal trespass charge, the state's recommended a fully suspended sentence.
Sorry, the contempt charge.
Pardon?
On the contempt charge.
Sorry, the contempt charge. And the court is convinced that this also requires a sentence. And it would be 12 months in the House of Corrections with 11 suspended for 2 years under good behavior. Again, good behavior means no felonies, misdemeanors, or major motor vehicle violations. And it would be 30 days to serve consecutive to this sentence. Irrespective of the constitutionality questions that were raised, the point is that there were some orders in place, and the violations of those orders were blatant. I don't buy the argument that the behavior didn't have a threatening component to it. Now, there's a bit of a procedural issue we have to deal with. Because of the motion to impose, there's no appeal from this court from that. So that would have to be served unless you were able to convince the Supreme Court to hear this and make an order, but otherwise that would be a stand-committed sentence. You can't appeal to the Superior Court for a jury trial on the contempt charge that we just tried.
Your Honor, and I would just actually add that I filed a motion to hold it as the contempt trial as a bench trial, so he's not entitled to a jury trial if the court sentences him to no more than 6 months.
My sentence would be 12 months.
Right, okay, so I just, it was granted, that motion was granted. I understand the court's position.
Well, is it your position that the court was bound to sentence him to 6 months or less by virtue of that motion?
Yes.
And what's your position on that legal?
On the appeal?
Well, on the legal point, in other words, I didn't see that there was a motion apparently in the other case like on a contempt charge. The state filed a motion here that I didn't pick up on that said that they were not going to seek anything more than 6 months. When they do that, that essentially means that whereas if it was a straightforward Class A misdemeanor and he was sentenced irrespective of the sentence, you could appeal to the Superior Court for a jury trial. On a contempt charge, it's in a little different category, and you don't get a jury trial. So I had to amend, because of the state's motion, I had to amend the sentence I just rendered down to 6 months with 5 suspended and 30 days to serve. So that the issue here is when he would begin to serve these 2 sentences. be some time to talk to him about when he would begin.
The defendant would ask for 30 days at least as a minimum before imposing a sentence.
And the reason for that is what?
The defendant was recently given the ability to have visitation with his son, and he would like to get some time in with his son prior to having to sit 30 days in jail.
Well, actually, it's going to be consecutive sentences, so 60 days. With good timing, you can get. Did you have any pretrial confinement on this charge? Is that a court order that you got visitation, or what was that?
No, just my parents let me see him prior to recently, now they do, so.
Well, we had some issues in the past with the mother of the child. Those resolved? Are they?
Yeah. Yes, has nothing to do with the mother of the child.
So the child is with your parents? In Troy? Or?
As long as it's
What time of day do you want to appear?
doesn't really matter.
Noon?
Sure.
Yeah, that's fine.
No, I think 30 days is probably too long to give it to Tuesday, July 1st at noon.
Your Honor, my birthday's July 11th. I'd really like to not be an occasional birthday.
No.
It's my 21st birthday. I'd really like to not spend that in jail, please.
We'll leave it at that. That's for now. There are also 3 bail fees that are owed. I'm not going to impose any of the fine. Mr. Coulson can't pay any of those fines anyway. All right, thank you.
Thank you.
One quick thing before this gets over. I do have a court date about a week from now on June 25th, and I wasn't aware of when that fell. I have had plans during that week for quite a while now. And it would be great if I...
June 25th?
Yes.
For what?
I have to come in here and show you proof of community service. And I was just asking if that could be extended like a week from then. I just had plans that week for
So you...
people from now.
So when do you want to come in with that?
I mean, any time after that week. Could be like Monday or whatever.
What day is June 30th? If you came in on June 30th, would that be okay? It's a Monday?
Hold on.
That's the day before you jail sentence.
Okay. Yeah, that's fine.
Okay. I will change that.
Thank you.
June 30th. Okay, thank you.
Recess.
We'd like to invite you to visit freekeen.com. Freekeen.com features audio, video, and blogs chronicling the transition to a voluntary society. FreeKeene.com also has comments and discussion forums so you can be heard. FreeKeene.com.
I should be in Keene, New Hampshire with the Free Staters.